ahead and get started. Uh, just a little FYI, I am at home today doing this presentation. I do have dogs, so there might be a moment in time where the dogs bark a little bit. My apologies for that in advance. My name is Phil Sever. I'm an attorney. I'm a partner at Sever Walker Padgitt, and we are eminent domain attorneys for landowners. So we work exclusively for landowners. We work all across the country. We have worked in Iowa pretty extensively. We've done a lot of pipeline and power line work in Iowa. I want to say that conservatively, I personally have done close to 1,000 pipeline cases. I represent at least 1,000 different landowners in pipeline cases, and our firm has a very, very deep level of experience dealing with the pipelines and in particular some of these carbon capture issues. So I do want to get started. I'm going to go ahead and share my screen, and we have a presentation I'll walk through. The presentation will take about 30 minutes, and then I'll do some Q&A afterwards. Hopefully you guys all find this helpful, and you can get some pieces out of this as you begin to deal with Summit. All right. So this is our landowner presentation involving the Summit carbon capture pipeline. This is a couple, just so you know who the people are who are working on these on this particular issue. It's me. I'm a co-founder, partner of Sever Walker Padgitt. This is a picture of me with actually more hair than I have now. So I probably need to update that picture. George is one of my partners. He is also working on these particular cases and has a lot of background in negotiating with the pipeline and power line companies. So any type of easements. Real quickly, our mission as a firm is to help educate landowners. I think that if you educate people, whether they decide to hire an attorney or not, I think an educated citizen, especially when it comes to eminent domain, is really important. And so understanding what your rights are, what some of the things you can and can't expect in these type of situations, I think is super valuable. So we're going to spend a lot of time just increasing your knowledge base, letting you know more of it's just things that we think that you should know. The other part of our mission is we want to fight for landowners' basic rights and condemnation and eminent domain processes, and that includes pipeline and power line cases. We want to hold governments and powerful corporations like Summit accountable. And you can find out a lot more about us if you go to our website, landownerattorneys.com. This seminar is being recorded, so if you want to watch it again, share it with a friend or a neighbor or relative. It will be up on the website in a couple days. You can find it on our webinars page, and you can then share the link or review it again at your leisure. So let's talk about Summit. Summit is a company that is trying to install these carbon capture pipelines. And this is a little bit of a new technology. It is certainly something that is not traditional, like you might find traditional pipelines that are moving natural gas. We've done a lot of natural gas work in Iowa. You might find crude oil. But this type of carbon capture piece is really related to some energy credits that I think some like Archer Midland Daniels is trying to take advantage of from a tax perspective. So there at one point was a variety of different carbon capture projects that were being proposed in Iowa. There was Wolf, Heartland Greenway, Navigator. A lot of them have gone away. They didn't find a lot of traction, and they didn't get a lot of assistance from Iowa, the regulatory commissions there. And so they kind of went away to a large degree. And that really left Summit. Summit has continued to try to install its pipelines, and to a large degree has taken over a lot of what was previously Navigator's sort of footprint. Where's the regulatory process at right now for Summit? So Summit has what I would refer to as a conditional approval in Iowa. That means that they are conditionally approved to use eminent domain to take landowner property. So that means they have a right to take landowner property. But this is conditioned on them being able to receive permits and approvals from various other states that are surrounding um, Iowa. So, for instance, Minnesota, Illinois, in some instances, North Dakota, South Dakota. Some of those states, North Dakota, Minnesota, I believe, have been working with Summit and have reached the sort of approval stage with Summit. South Dakota has gone the other direction. South Dakota actually passed a law that says that you cannot use eminent domain uh, for carbon capture pipelines. So South Dakota has taken a very hard stance. Summit's response to this has been sort of interesting. They still seem to think as if their project is going to go forward. Um, Without the power of eminent domain, I think that they're going to have some uphill challenges in South Dakota, but they still seem to be wanting to push forward. I guess at the end of the day, what I'm really saying is that the Summit project is something that's probably a 50-50 proposition at this point. I don't really talk about these projects as being, uh, if you have a natural gas pipeline, you can pretty much, and it's been FERC approved or approved by the federal government, you pretty much expect that that pipeline is going to go in. These carbon capture pipelines, I think it's a little less clear as to what's going to happen in the future. Although Summit appears by all measures to still be pushing forward. We have clients on this extension. They are talking to our clients. We have clients on the main line, the old main line for Summit. So they still appear to be wanting to go forward. They've got some regulatory hurdles though to overcome. So to me, it's not 100% open and shut case as if they're going to be able to install their pipeline. So let's just maybe fast forward past that issue and talk about what if Summit kind of gets its approvals and or a landowner wants to negotiate with them regardless. There are usually two landowner issues that should be focused on at the end of the day. You can't really ignore either one. You've got to pay attention to both issues to get the right result. The first issue is you need to make sure that your easement is as quote unquote friendly or favorable to the landowner as possible. Now, you're not going to be able to negotiate everything in your easement, but there are certainly points that need to be negotiated, that need to be looked at very carefully. When they first slide that easement across the table to you, that is an easement that is most favorable to them. And I would argue whether you hire an attorney or not, you should never sign that first document. You should negotiate some portion of it. This is probably step one. When we bring a client on board, this is really step one for us is negotiating the easement language because everything sort of flows from that. Compensation and the rest of it flows from easement language. So we really take we do a lot of diligence on making sure the easement is negotiated properly. You want to, as you'll note from the slide, you just want to make sure that you include remediation and damages into your easement language. You want to make sure that it limits the rights of the pipeline as much as possible. So, for instance, sometimes easement language will say, we are allowed to install pipelines, plural. Well, if they are only putting in one pipeline, you shouldn't give them the right to install multiple pipelines. There should be another opportunity to negotiate if there's more pipelines that need to be installed in a later date. So you want to make sure you just pay careful attention to the easement. It's one of the first things we do with all of our clients is look at the easement language. You might have some. I think some of you have offers already, so you might see exhibits that look like this. You'll see a diagram, property line. You might see temporary right of way. You might see workspace. You might see the actual easement itself. You also want to be careful about access. Does the easement talk about access and what type of access is allowed to the property? Are they gonna be accessing from anywhere or accessing from specific parts of the property? How do we limit access? How do we make that better for the landowner? There are a lot of different pieces to that. Remediation, if you're going to put this big pipeline in, how do we make sure that the soil that is left, that is used in the process, is put back in the same condition it was before? So it wasn't mixed, and the bad soil from the bottom ground is put up on top where the topsoil used to be. There's a couple things in there that we can drive into easement language that I think is really important. The second issue is compensation. So a lot of landowners know they are entitled to compensation. They're not really sure how to increase it. And this is where council can be really helpful. There's some other things we're going to talk about a little bit later in the presentation I think are helpful for increasing compensation. But to a large degree, you really only have one chance to make it the right compensation deal in these cases. So compensation needs to be looked at very carefully. You need to look at a residue. You need to look at how the pipeline affects the rest of the property. You need to look at how the pipeline impacts irrigation, tile or pivot or whichever type of irrigation you're doing. There's a lot of different factors that go into compensation, cost to cure damages. Um, they're always missing on per acre. But what you want to make sure you do is that you don't play in their ballpark. And we're going to talk about that here in just a second. So like I said, we represent, I should update the slide deck, thousands of pipeline owners. We use a bunch of different strategies. Two of those I'm going to talk about a little bit here today with you guys. And one thing you want to look at, I think that you want to look at the property holistically. So the whole property, I kind of think of it like a piece of paper. So you have a piece of paper, the piece of paper is worth something, right? If I take a pencil and I draw a big X across it in the middle of it, the paper can still be used as paper, still write on it, you still make notes on it, but it's not worth as much. And I think the same thing can be said of properties with pipelines on them. It's just introducing something to the property that didn't exist before, and I think it has an impact on the rest of the property. So you can talk about residue damages, you can talk about field tile water, operational efficiency, soil mixing, compaction, topsoil loss, weed and insect control, loss of building rights. Maybe your property is situated in such a way that it could be used residentially in some spots or commercially. Impacted development needs to be taken into account. So a lot of different factors and strategies that go into the compensation conversation. But one of the things that we think is really effective is using leverage in terms of a group. So when you have a group of landowners that are all together working in concert and trying to get better easement terms and better compensation language, it has been our experience that better results flow from that. Where you've got a lot, we just finished up a case in Tennessee involving a natural gas pipeline, and we had really good results. We were able to increase landowner compensation considerably, and that was really because we had 25 landowners together. And at the end of the day, the pipeline company is trying to make money, and we represent a significant litigation obstacle if they were to have to bring lawsuits against all of us. So that is one way, and there's other ways to leverage the group at the end of the day, but this is, I think, a really important concept. And so when we're talking to landowners, we're really trying to get groups of landowners together under our representation so that we can leverage that landowner group to provide better results. One of the things is that timing matters. Every case, every negotiation has really a sweet spot in it where where you can maximize results for the landowner. And in this case, I'll tell you right now, the sweet spot is not here right now. That's for sure. Um, if I was to speculate, I think that Summit is just trying to pick off low hanging fruit right now, get people to sign deals and see what the landscape looks like. They don't need anybody yet. And so, from our standpoint, we're not talking at all with them about compensation because we just don't think the timing is right. But timing is going to make a big difference because there'll be that kind of unique moment in time where you need to strike to maximize results. And I think this is also really important. If a right-of-way agent comes to you and they've dropped off an offer and they say they want a response within 5 to 10 days and they rush, 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 don't rush. Whether you hire an attorney or not, whether you work with us or not, do not rush. The easement could potentially be forever. You do not want to give up. You want to clearly negotiate your easement rights and your compensation. And if you rush, you're going to make mistakes that you will regret later. So do not rush. You got really one chance to make the right deal. I'm going to talk a little bit about this is sort of a unique situation. All right. So because I honestly believe that Summit is something that may or may not happen. They have been offering options. So an option is a negotiation that says, I'm going to pay you X number of dollars up front for a right to buy your property in the future for X number of dollars. So you've got to negotiate not just the back end, like what you're going to get paid in the back end, you need to negotiate the front end. And when you're negotiating the back end, you also have to keep in mind the time length at which they can execute this option, because the price of land is not static. You want to make sure you build in some of these inflationary numbers into your eventual resolution. So there's a lot of things to take into account there. But some folks, and I'm not telling you one way or the other, in other situations, I might be like, well, they're going to put the pipeline in. You really need to get involved and get active right away and come work with us. But in this situation, I'm going to say that there's a chance that Summit doesn't actually happen. Some landowners may choose to try to negotiate a deal and get this option money up front. And with the idea that, well, if I put the right deal together and Summit happens, then I'm satisfied. And if I put the right deal together and Summit doesn't happen, I got paid something. I got this initial option payment. I never had to give up my ground. So that is one strategy. I think that if you're a landowner thinking that way, certainly feel free to give us a call. Some of you may be saying, well, I want it to go away. I don't want anything to do with it. And you might be more inclined to sit back and wait and see what the regulatory environment, how that kind of matures and what happens. We've dealt with some of these easements where they've had regulatory hurdles. Some of the projects go away where they have big regulatory hurdles, but some have real staying power. They really stick around. There's a large power line that goes through the central part of the country called Grain Belt, and they've had hurdle after hurdle, but they continue to acquire and push forward. So this could be the case with Summit. They just got so much invested. They believe that they're going to make so much money that they're going to keep pushing forward. So, like I said, we have clients working with us right now, and you may choose to do the same. We're always happy to talk and chat. So right-of-way agent comes to you. Some of you have offers already, some of you don't. Right-of-way agent comes to you Here's some tips that you may want to just maybe take a picture of this on your screen. Here's maybe some tips I would recommend for dealing with them. I don't necessarily recommend meeting them in person. You can meet them in person. That may be that's fine, but I don't necessarily advise that for my clients. I think these guys are professional land buyers and they're trying to get information out of you so they can use that against you at a later day. In a lot of instances, I have seen where a land agent has gone out and said, talk to a farmer and said, what do you think? That farmer gives them a price, starts talking numbers with them. That farmer then comes to us. Our analysis of their takings says that they're entitled to more than he was saying to the land agent. And then the land agent is telling us, well, I know your farmer would take A, B, and C. That's what he told me. What are you talking about these other numbers? So you just got to be a little bit cognizant of that. I also like to have things in writing too. I think that makes things cleaner. Land agents, these guys come in, they buy land, and then they disappear. So if they are giving you oral promises or oral offers, and they're saying, well, we'll take care of this, we'll do this, that guy or gal is never going to be around again after they've got your signature. And any oral offer or oral promise they gave you is not enforceable. So I've seen landowners come to me after they've signed deals and said, well, he promised they would do A, B, and C and on the phone. And I'm like, is it anywhere in writing? No, it's not in writing. Can't enforce it. So don't accept oral offers. So again, everything in writing. I'd ask them to email the offer package to you. If you're doing any negotiations on your own with them, I'd have them put all numbers in writing so that there's no miscommunication on numbers. After you get the package, just tell them you're going to take a week, at least a week, to get back to them. They should, although they may want to speed you along and rush you along, there is no rush right now for you to make a decision. And then if you want, you can send your offer to us to be reviewed. So we'll do reviews. We do reviews for free. You may be thinking, well, Phil, you're just attorney. How do you get paid at the end of the day? So, I mean, pretty easy concept. We get paid if we add value. So in the event that you've got an offer, and I'm going to use some round numbers, in the event that you were offered $50,000 and you bring the case to us and we say, yeah, that's something we're interested in, we think we can help, and we go out and negotiate another $50,000 as an example. We would take a fee, we take 33% of the amount that we added. So you were offered 50, you got another 50, we take 33% of the 50 we added. We do not take any portion of the amount that you were offered initially. So, and this also means that part of our job is to look at your offer and make sure we can help. We don't necessarily want to take on clients that we can't produce a good result for. Now, I've seen the Summit offers. We have not turned away a Summit client yet. I just think that there's a lot of room for improvement in these offers. So that's a little bit about how we work. Again, don't go it alone. They're going to have trained counsel, whether you hire us or hire another attorney or hire another professional. I just really be cognizant that this is a big decision, and you want to make sure that you're not trying to put it all together by yourself. Again, this is, I got jump a little ahead of myself here. This is how can I afford to pay an attorney? Again, we work on a contingency fee basis. We can do hourly, but it's highly unlikely we accept any hourly clients on this particular project. Again, we'll look at your offer for free. Fax or email me with your offer. We'll tell you if we think we can add value. If we think we can add value, we'll offer you a contract. and get you started in our process. But again, this, like I said before, Summit is not this. It's not this 100% certainty. Some of you may decide that you're going to sit it out, sit on the sidelines for a while, and see where the regulatory environment goes. I will tell you this: we can't make deals without you. So if you were a client of ours and you said one day, Phil, I'm not going to make a deal, but keep lines of communication open with Summit. That's absolutely what we're going to do. We are in no hurry to make deals with Summit right now. I don't think it's the right time to make a deal, but we are trying to collect clients. So if there is a time and place for a negotiation, we have maximum leverage. I talked about that exhaustive. So please feel free to reach out, check our website. These are some phone numbers. You can also see, I'm going to stop sharing. Go back to here. So that's my presentation. I'm going to go to the Q&A and answer questions. So please feel free to drop into the Q&A, and I'm happy to answer questions. And this just applies just generally. My job in a lot of ways is talking to folks every day about their eminent domain issues. And so if you just want to pick up the phone and pick my brain about what's going on with your problem, I don't have any problem. I mean, I'm happy to talk to you. And George could talk to you. Anybody at our office can talk to you, because this is what we do. We serve landowners. So let me look at the Q&A here. All right, so the first one is a question. Given all the Doge cuts, there was a December article that said that President Trump had promised to rescind all unspent funds of the 2022 Inflation Reduction Act. We wonder if the tax credit per metric ton of the sequestered carbon could possibly be eliminated, which would affect the economic viability of somebody's project. It would happen anyway, even if we did sign it. So I think that's pretty astute observation by the question. Right, I think that this project is inherently driven by tax credits, but who are the tax credits for? As I understand it, it is for ADM. This is a huge corporation. They have a lot of lobbying power. They want these tax credits, and I think through the things I have seen, a lot of this pipeline and power line work that you may have thought that would not be emphasized under the Trump administration is still going to happen. I mean, we're doing tons of this work right now, so I haven't seen really a shutdown on these particular things. Just another quick question was the fee that Sever Walker Padgitt charges. We don't charge a fee. We take a percentage of what we add. So, I mean, at the end of the day, we take a fee, but you don't need to come out of pocket or write us checks to get our representation. There was another quick question. There was a probate question in the chat. I would say that if you have property in probate, then it's being administered, and if you wanted to make a deal with Summit, the executor or the administrator of the estate would have to be involved. There's a question here about mineral rights. See if I can go parse this. Yes, they say one question I have is that the easement is negotiated and they mess up the land or create any sort of problem, what forces them to honor their agreement with the landowner? There's actually a couple of ways to do this. First of all, you want to have a remediation language in your easement agreement. Remember, the easement agreement is the document that controls your relationship with the pipeline. So if the easement agreement says the pipeline has an obligation to remediate, and there's damage to your property caused by the pipeline, you can bring a lawsuit against the pipeline and you would probably talk to them first, but then if they weren't responsive, you would bring a lawsuit against them to force them to either pay for the remediation or enjoin them. That means force them to do remediation themselves. We had this issue and here's another positive about Iowa. Iowa had, in particular, requires remediation, like the Iowa Regulatory Commission, which governs a lot of this pipeline activity, has a requirement that remediation occurs on the property and that pipelines must remediate. So you've got not only the easement agreement, but in this case, you've got like the pocket ace in your back pocket where the regulatory commission is saying, pipeline, you must remediate the property. Remediation is really important. That language has to be really strong in the easement document. So if you're out of state, you have other pipelines, you want to make sure that that easement language is really strong. Good question. What time frame do you think they have to start, assuming they get approval? If they get approval, things will whip up really quickly. I think that you would see or a kind of like a 6 to 9 month time frame where they would get moving very, very quickly. They would wrap up the rest of the easement negotiations to the extent that they could, and they would bring lawsuits they had to acquire the rest of the ground. We're not there yet, but if the dominoes started falling where approval looks imminent, you certainly want to be really paying attention to that because your sweet spot when you're going to be able to strike the best deal is coming up. Good question. Does ADM own Summit? I do not believe they do. They own Summit. I just think that there's a very cozy relationship between the two, and that a lot of this carbon capture is used to sequester carbon produced by ADM facilities. So another really good question. Gentleman says he's a certified general appraiser, agrees with the initial offers for the land and damages is low. Um, they were involved in Summit's phase one project and they negotiated cash payments up front. The options are less attractive, and the leasing agent indicated they will consider cash counteroffers. That's a possibility to do more of a straight transaction up front. I would argue that the deals we're putting together for folks, I don't know if you would see the type of money we're asking for be part of a cash offer. I think you have to take a discount to do like a full cash offer um, at the start of the project. I'd also say in this particular instance, the where it's uncertain whether Summit's going to get the rights to actually do the project, that options make a lot of sense. I mean, I'll give you a perfect example of, I had a group of clients in Utah that had options, and there was a lot of hem and hawing, and they just couldn't, they wouldn't, because the clients have to say yes. I put together what I thought were really good deals. The clients were kind of sitting on their thumbs a little bit, taking their time. They could have executed the options, put the money in their pocket, but they couldn't like make a decision. And unfortunately, the project like went away within weeks of us getting the final numbers in front of my clients. And so, like in that instance, if they kind of moved a little bit faster, they kind of hit the sweet spot like I was telling them to. We would have had cash in hand and no project, which would have been a great result. So maybe somewhere in this process is for you as an individual farmer, landowner, representative to think about what that means if you can strike the right deal, gain an option payment with the possibility that they may never do it. Next question is, how much does CO2 pipeline typically decrease the land value? That really depends on how it's traversing the land. So whether it's going through the entire farm, so sort of through the center of the land, on the edges of the land, cutting a corner of the land, that all kind of varies in terms of its residue impact at the end of the day. But a lot of our calculations are based around the idea that there is residue, but there's also leverage from our group. You have option for getting them to change the path of their easements, especially if it goes diagonally across multiple fields? That's a good question. I think that if there's an opportunity to do that, it's probably in this sort of space where they don't necessarily have all their approvals, but and they might be willing to make adjustments to the pipeline now. I can't guarantee it. Some companies are more likely to change pipeline routes than others. Um, Natural gas is unlikely, but these type of pipelines, I think you might find some receptivity there. At what point, how long before Summit would start eminent domain if we keep saying no and just sit back to see what happens regulatory wise? Well, they really can't do anything until the regulatory environment clears up for them. So you can keep saying no until they get approvals. At the point they get approvals, depending on where they are in their process, let's say there was only four of you left at that point. They're they're probably not going to give you much time to negotiate. They would probably go ahead and file those lawsuits. If there's 50 of you left, and even if they have approvals, they're probably still negotiating at that point. So that's a little bit of the art of negotiating this particular and where you are in particular, whether you're part of a group and what has happened. I will say this. I maybe should emphasize this about a group. In a group situation, everybody's compensation will be different because everybody's land is different and the impacts by the pipeline are different for everybody. Uh, but you're using the group dynamic as to say, hey, there's a lot of potential costs and risks for you, Summit, down the road. You need to deal fairly with this. What are the implications? This is a really good question. What are the implications? The property was set to go on the market sometime soon. So I would say that if you're going to sell the property, it would be my advice as just to be very cautious and make sure you disclose. So what you don't want to do is sell the property, do not and not disclose that a potential pipeline is coming on the property, and then have the landowner turn around and look at you as if, why didn't you disclose this, and um, get yourself into a problem with them. So another question. Uh, if you could, Jim, could you just maybe rephrase that? I'm having trouble understanding the question. Just take a little more time to type it out. Well, so how do landowners form the groups you're talking about? What's the process? Like we've already. This is why I'm here today. Um, Landowners that work with us are going to be part of our team as we push forward. So, like I said, we already have landowners that are working with us. They would be part of our group as we negotiate with them. I do want to be clear, we are not stop the pipeline guys. So we're trying to get the best deal for landowners. So you are gung ho, stop the pipeline, we're probably not the right team for you. But if you're looking down the road to say, hey, how do I get the right easement? How do I get the right compensation? Then we're happy to help. I'm going to try with Jim's question. He didn't retype it. Um, he says, organized opposition is watching out of fear of a leak. Who is doing what in pipeline construction? Some longtime neighbors living near the pipeline are using fear and friendship to discourage participation. How bad can it get? So maybe what the question is there's opposition to the pipeline because there is fears of a contamination leak from the pipeline. I think I think although not something that is likely, it's certainly a risk that's added to the property. So when you think about like your standard piece of ground, you're buying it, when it has a pipeline on it, you buy risk. Now, even no matter how infinitesimal, it has risk associated with it. So that, to me, that affects value. And that's one of the talk tracks we have. Hey, we have this pipeline. it's probably not going to leak, but there is a risk that it does. And so this risk influences the market, which influences value. So again, to me, it's a value proposition. I'm sure there's organized opposition to this pipeline. I know that there's very much organized opposition in Illinois to the carbon capture pipelines. It's interesting to note that Indiana, where I'm headquartered, we passed a law to allow carbon capture pipelines, which is for a state that's very, very Republican, was kind of surprising. So the I think that big business is speaking a lot to this, and they want these tax credits, and I don't think they're going to go away at the end of the day. So I'm going to take one more question, and then like what I'll do is I just encourage folks, if you have more questions, individual questions related to your own situation, you want to send me your offer to look at, please feel free to reach out. And I will confess that I'm going to take a couple of days off. I'm going to take Thursday and Friday off. My wife wants to take a vacation. So, but George Padgitt, who I introduced earlier in the presentation, will also be available to answer any of these questions. So, and I'll be back Monday. Last question. We cash rent our farmland. How does pipeline issue affect our ability to rent our land and the per acre rental rate? I certainly think it will have an impact on rentals during the construction period. I'm not sure what the rental rate issues will be after the pipeline. It kind of depends on like how the pipeline impacts yield. And yield, I think, drives rental rates to a large degree. We've seen some instances. I did Rex pipeline cases that they stretched all the way from Colorado to Ohio. And you can actually look on Google Earth now and see where the pipeline is, because the pipeline ground doesn't grow as well as the non-pipeline ground. So if there's an impact to rental rates and cash rent, it's going to be because yield goes down. All right, folks. Hey, thanks a ton, everybody, for being here today. I hope that you got some information out of this seminar. For those of you that are interested in talking more and having your offers reviewed, like I said, please feel free to reach out. This webinar will be up on our website, so if you want to share it with anybody, I think the Q&A was really good today, so a lot of people can get something, I think, out of the Q&A. My number to reach me, 317-575-9942. And my email, phil@swp-legal, legal.com. And the partner that's also working on this is George Padgitt. George can be reached at george@swp-legal.com. And we'll also follow up. I think that those of you that put emails or gave contact information to the Zoom, we'll run those into a spreadsheet, and then we'll reach back out and make sure you guys don't have any questions. Again, thank you very much. Good luck to all of you. If we don't never chat again, hopefully you got something out of this. But those of you that have questions and concerns, please feel free to reach out. Okay, and enjoy the evening. Take care.